We're back on the air. This is Radio Entrepreneurs. My name is Jeffrey Davis, and I'm having a good time because I'm with my esteemed colleague from the law firm of Cohn, Rasnick, Myerson, and Plout, and that must be Peter Myerson.
It is, Jeffrey. It is, as always, great to be here.
Our next guest, since that's the reality of what we're really here for, is, and I hope I get it all right, is David Boundy of Cambridge Technology Law. Welcome, David.
Well, glad to be here. Thank you.
Do you want to tell us a little bit about Cambridge Technology Law?
Well, I'm in my mid-50s and spent all my career working for other people and being in big law firms and being in-house counsel, helping run a fairly big company, and decided that it was time to just do some things on my own that I couldn't do as long as I was working for somebody else. So I, about 18 months ago, went out on my own, had a few clients to start doing some kind of important and interesting things for, and you know, like every other startup, there are bumps in the road, but it's mostly fun to be in control of what I'm doing and choosing what to do. And so I largely help startups. That's where I really have the love, is finding companies that are starting up that have got a great idea and are looking for ways to keep their market niche protected.
Wow.
That's interesting. I mean, you and I are in fairly similar spaces. It's slightly different perspective. I come out of two fairly large law firms, but now have other partners. And so what do you see as the challenges for entrepreneurs? What do you think the major issue is for your clients who come in and see you, aside from getting them in to see you?
There was a big change in the law about 3 years ago. Until for 150 years, the patent law had been very friendly for startups. That the law worked basically at the speed that a startup was comfortable with. In 2011, a law was passed that I tried very hard to stop, and I stopped it for a year anyway, that just changes the deadlines, moves the deadlines for patents to be much earlier. So one of the big challenges is that there's now a big catch-22. It's a lot of investors don't want to talk to startups until there's a patent application filed, but it's very difficult to get a patent application filed until you have an investor. And so that's become a big challenge, is that chicken and egg problem.
You're talking about the cost of a patent application.
Yeah, and so
everybody thinks it's like $40, and it's not.
No, to get a patent application that does more good than harm is, depending on the kind of invention, it's $4,000 to $20,000, depending on the complexity of what's there.
So do you see provisional patents as helpful or not helpful?
A provisional patent application was something that was created about 10 years ago, and it's a good concept. The idea is that it's a patent application that fully discloses the invention but doesn't have to observe all of the formal I-dotting and T-crossing. But the stress point there is it has to be a full disclosure. It has to have all of the technology in it. And so the problem is that they're seductive. And
because they're cheaper?
Because they're cheaper, because...
But there's a downside.
Yes, because they're less expensive for the filing fee, but too many individual inventors think that they can do it themselves without somebody looking over their shoulder.